right. So welcome everyone to the SCMA Rules Revision Background to Public Consultation webinar. So thank you very much for coming along. I will just quickly go through some of the admin procedures and also then give an introduction to the panelists and also try and give you a bit of background to why and how this webinar is going to be functioning. So just a little bit about the admin part of it. We are going to have question and answer sessions at the end of this session. There is a Q&A tab at the bottom, which you can click on and use that to post your questions. You also have an option to raise your hand, as in virtually, digitally raise your hand. And I will try and unmute you for asking the relevant question. And then, of course, you'll be muted. Default setting for all the participants at the moment is, or the attendees is mute. And that's the status at this point of time in the webinar. With regard to the participants and the panelists of this webinar, I would like to introduce Andrew Moran, which is the chairman of the SCMA Procedure Committee, Kenny Yap and Sapna Jhangiani, who are both members of the Procedure Committee of SCMA. So first of all, I would like to thank all the current panelists and the entire Procedure Committee for their work on this rules revision. And also thanks to two of our board members, Corina Song and John Simpson, for helping out with this public consultation document as well. So thank you very, very much. Of course, SCMA rules, the current rules were put out in 2015. So obviously, with the maritime arbitration scene constantly evolving, this rules revision was always on the card, something that we were always looking to do. And I really think it has gone through a decent amount of feedback that we've got from various users on which we have tried to base this particular rules revision, proposed rule revision, I must add. And to give more information about this, I would actually pass you on to Andrew. Andrew, you can start now and give the feedback and the background on what this rules revision is about and how do you actually expect feedback to start. Yeah.
Well, thank you very much, Puneet. I would also like to begin by thanking all members of my committee, a substantial committee. I'll give you some detail of that in a moment. And also particularly the members of the board and Corina and John, who've helped me greatly in progressing this rules review. So if we can just look at slide number 3, have that on the screen to begin with, Puneet. I'll give, first of all, a word about the background to this consultation, setting it in the context of the reincarnation of the SCMA back in 2009 as an independent and freestanding, that is from the SIAC, Chamber for Maritime Arbitration, in the unadministered ad hoc tradition distinctly favoured by maritime parties and with which the industry has long been comfortable and familiar. This review and consultation is not about reinventing the wheel, but about development and progression of a tried and trusted form of arbitration for maritime cases, capable of the widest use possible in different types of maritime case, which is a distinct objective in these rule changes and in further promotion of the SCMA. We seek to make it more efficient, responsive, and user-friendly wherever possible. So the background, it's come about with the setting up nearly 2 years ago by Go Jun Seng, our former chairman and the board at that time, of a wholly new procedure committee under my chairmanship, with its first and principal task being to undertake a review of the rules leading to the consultation we are now launching. It's important for me to record Jun Seng's brief and his outward-looking ideas in the formation of the committee, which was to assemble the widest possible membership in terms of all of the following: maritime specialisms, practicing location, nationality, global industry representation, particularly with 2 senior P&I club directors, different clubs I should say, as members of the committee, so that we have representation of the widest possible client and party constituencies of actual and potential users of SCMA arbitration. Shortly, we have on the committee representation of interests and all types of maritime specialisms coming from London in the west and spanning the globe through Singapore to the eastern maritime hubs in China and everywhere else in between. The object of that assembly was to gather from the personal experience and connections of all of the committee members ideas for improvement and reports of dissatisfaction or suboptimal, we don't have bad experiences with SCMA arbitration, just suboptimal experiences, so that we can put things right. This was the first step in the review of the rules. The members of the committee all produced independently their own written reports to me detailing the concerns and ideas that they had become aware of or experienced for themselves from their client base and from their working base. And upon coordination, it became clear that there were particular areas of common concern and common ideas from improvement coming from all over the world that needed to be addressed and considered. Possible rule changes were formulated by small groups of committee members, and I should say collective responsibility for them is assumed by all members, but not all members agree with all of the possible rules that you will see in the documents to which Punit will refer you shortly. So now looking at this slide 3, which is on the screen, it explains the 3 areas in which possible, I've used that word a number of times now, and I'll explain in a moment why, possible rule changes have been considered and how they have been fed into the consultation. So there's 3 areas, 3 sections. As to A, little needs to be said. These are the tidying up amendments to resolve minor ambiguities and lack of clarity, which has become evident in use of the rules over the last 5 years. Everybody is welcome to respond in the consultation to anything else they might spot that we have not spotted. So all is welcome on that one, but we're not going to focus on that section or area today. As to B, this is the component of the consultation work that has formed the major part of the procedure committee's work. And it resulted in a report to the board with possible, I'll say it again, not proposed. I make that point of emphasis very clearly. Possible, not proposed amendments for improvement of the rules to go out for consultation, together with a commentary or rationale for the possible changes. And this report, with that rationale in respect of each rule change, is available to consultees as part of the consultation, and Punit will explain how and where to access that material later in this webinar. And as to C, of course, an arbitration consultation would not be a consultation without asking about the ideas of the moment in international commercial arbitration generally. And I will speak to these possible structural changes, if I can call them that, later in this webinar, on which consultees may feel the need and wish to comment. Now, before I come to dealing with the possible changes, I do want to say this. The committee does not presume to be in any way omniscient as to what might be required to improve the rules. The committee was merely carefully and deliberately assembled to make a start in finding out what might need to be changed. It is you, the consultees, who will make, and we hope you will make, the vital contributions, short or long, in droves, so that by analysis of all responses, the SCMA can be clear as to what amendments will best serve users of SCMA arbitration in resolving their disputes under its rules. robust and reasoned disagreement with the ideas for possible changes and our rationale for each of them is every bit as welcome as agreement and approval. Please expand, you'll see them listed in the rationale in various cases. Expand on the pros and cons. We've put them there as we see them, but there may be more on both sides. So do not hesitate to expand on those when you respond to the consultation. And please do not hesitate to improve on the drafting of the possible new rules as you see fit. So all offerings will be welcome. So if I can move to the next slide now, slide 4.
Yeah, just Andrew, you want to confirm the period of consultation is already on from now to 31st of August?
Yeah, sorry, thank you for reminding me of that. The time is not too short, but it is limited. So we do ask you to respond, to read the materials and respond as quickly as you can so that we can get on with the work of reporting to the board upon an analysis of the responses in the consultation. So there you see the period on the slide. Thank you, Punit, for reminding me of that. So if we go to the next slide,
yep.
The way we're going to do this, ladies and gentlemen, is that the three of us, that's myself, Kenny and Satna, will give you a heads up or a taster of some of the changes that have been the subject of trial drafting. This is section B that I've just outlined to you as possible new rules. This is not in order of importance, but generally in the sequence in which they will appear in the rules. So I start here with notice or deemed notice. It is a vexed issue, as you will all know. It's usually a problem and feature of the unresponsive respondent cases. Satisfaction of due notice having been given can occupy parties and tribunals in a wholly disproportionate, costly, and we would venture an avoidable waste of time and energy. And we are looking particularly for those tech-savvy individuals to unburden themselves of the latest ideas for resolving this perennial problem. So we can move on now to the next slide, 5. This is rule 4. I just mention here that though it's not mentioned, the same issues arise with a new possible rule 5. I nearly made the slip then, didn't I? I called it a proposed rule. It's not proposed, it's possible. The consideration of this rule with rule 5 presents the dilemma between more or less formality and detail in the commencement of an arbitration and response to the notice. The dilemma is that more detail might facilitate better case management at an early stage. It might enable deflection to the small claims procedure at an early stage, and Satna is going to talk to you about that later, and it might promote more efficiency. On the other hand, it might encumber and make more difficult and costly the commencement of a reference, which by itself, as we all know, sometimes does the trick of resolving the dispute. Moving on, the next slide, 6, Rule 6.1. It's very brief, the proposal, but could not be more important. This rule, Rule 6, generally concerns the appointment of arbitrators, and first comes here a particularly important and sensitive possible change. Should we adopt the default position of a sole arbitrator in all cases, or in some cases, and if the latter, on the basis of what, if any, criteria? And the slide highlights, you'll be reading it as I'm speaking to you, some of the competing considerations. The pros and cons are listed quite fully in the committee report. I recommend you look at it, think about it, and please let us have your views on this very important possible change. Moving on to the next slide. This is new possible rules 6.2 to 6.4. And what I want to draw attention to here is the very important possible change by a new rule 6.3a. You'll see the form of its drafting in the report to the procedure, to the board from the procedure committee. which you will have access to, which allows a party which has appointed its arbitrator to appoint that arbitrator as the sole arbitrator if the other party fails to appoint its arbitrator within 14 days. This, of course, will be very familiar, this particular type of rule, to many of you who deal with London Maritime Arbitration Association cases, Arbitrator Association cases. It is designed to circumvent extensive cost and delay in constituting the tribunal. Again, the need for it often arises, or its benefit can be seen in non-responsive respondent cases. Its effect is to import by rule and thus agreement the effect of Section 17 of the English Arbitration Act. This is, we recognize, highly controversial, especially in this region, in model law jurisdictions. It was hotly debated in the committee, and it might, we recognize, give rise to enforcement problems in some jurisdictions. Thus, careful thought and considered views of consultees are critical in making a decision on this possible new rule. Moving on to the next slide, 8. Here, I would draw attention to the possible new rule 6.3b. Now, this reflects a practice having its origin in LMAA rules and practice, but they don't enjoy it all to themselves because it's already commonly adopted by consent of parties and arbitrators here in this seat in SCMA arbitration and in other seats where SCMA arbitration rules are adopted. So the question here is, do we need to change the rule so that two-party appointed arbitrators will proceed as a tribunal of two until a hearing, or they disagree? And on that, we really do need your views. The common experience, I'll just give this little aside, the common experience of the members of the committee was that if arbitrators proposed this as an idea, arbitrators familiar with the practice of two proceeding as the tribunal by agreement, parties almost universally agreed to it proceeding in that way. And it's a matter of sometimes arbitrator reluctance or lack of knowledge of the way that can be done, that this has not acquired more currency of use in this region. So that's an important one for your consideration. Moving on to the next slide within my realm of this taster. This involves the funding of the reference and securing the tribunal's fees. From this slide, I think the key takeaway is the idea of doing away with booking fees under Rule 29, which comment suggested to the committee was viewed as unwieldy and confusing, and which has largely fallen into disuse in favor of the generally voluntary use by parties and arbitrators of standard terms of appointment, the arbitrator's standard terms or an association's standard terms, however it may be effected. So the questions for you as consultees: should booking fees be removed completely from the regime for funding arbitrations, maritime arbitrations, and replaced with agreed or default published standard terms of appointment for arbitrators? What should those standard terms contain? All comments on these aspects of funding will be most welcome. And in particular, may I ask for, copyright not protected, forms of standard terms of appointment that parties use, that arbitrators use, so that we can get the best from them and hope that it doesn't turn out like the horse designed by a committee, the camel. So we ask you for that as a means to include, if it is what consultees recommend, at some place, either in the rules or on the website, some standard terms of appointment that might be adopted in lieu of the unwieldy and cumbersome booking fees that have applied not very much hitherto. And finally, in my realm, the next slide dealing with Rule 13, which is the Tribunal's security for costs. As a full-time arbitrator, I can speak freely about this, of course. The possible change is born of dissatisfaction with a part of the funding process that parties can, of course, never voice and never do voice, if they ever do voice it, until after the arbitration. Nobody wants to question or challenge the arbitrators about security or the amount of security for their fees before they come to make their decision. But this is a problem and it has to be faced. Consultees may feel that there should at least be some published uniformity of approach and guidance for parties and arbitrators, which would alleviate and avoid grounds for dissatisfaction. And once again, all ideas on this somewhat sensitive topic when it comes up in the course of an arbitration would be most welcome. Let's deal with it if we can in a structured and consistent way so that it doesn't give rise to dissatisfaction in parties who are funding these arbitrations. So I'm going to leave my part of the possible new rules and hand over now to Kenny.
Thank you, Andrew. Kenny, all yours.
Hi, everyone. I'm going to take you through the next 7 slides. Before I start, can I just check with you, Punit, that you can hear me clearly?
I can hear you clearly, Kenny.
Okay, all right. Then let's start with Rule 6.8, which concerns additional information required from tribunals. Now, the present Rule 6.8 requires the tribunal to inform the SCMA of its appointment, along with a brief nature of the dispute. Now, the purpose of this rule is basically to inform the SCMA each time an SCMA arbitration is commenced or each time there's an appointment. And this is so that the SCMA can keep track of the number of arbitrations and appointments it gets every year for statistical purposes. Now, the current rule requires the tribunal to inform the secretariat, the SCMA secretariat, of the appointment and a brief nature of the dispute. Okay, the question here is whether this is enough. And the possible amendment is to expand this a little bit to cover not just a brief nature of the dispute, but also basic information such as nationality of the parties, name of counsel, quantum of claim and counterclaim, substantive law of the contract governing the dispute, and the seat of the arbitration. Now, the possible rule specifically excludes the names of the parties. So don't worry, the names of the parties will not be disclosed. Okay. So in short, the issue for consultation is whether we should just leave it as brief nature of the dispute or whether we should expand it a little bit to cover the additional information I just mentioned, but excluding the name of the parties. Moving on now to the next slide. This is Rule 8, and the possible amendment here is the reduction of the time for delivery of case statements. Now, at the moment, Rule 8 provides for a 30-day period for parties to deliver their statement of claim, statement of defense, and statement of reply. So in total, there'll be 90 days for the filing of case statements. Now, the possible amendment here is to reduce this from 30 days for each statement to 14 days for each statement. And this will amount to a total of 42 days. Now, by comparison, I understand the LMAA provides for 28 days for claim submissions and defense submissions and 14 days for reply submissions. I've looked at the SIAC rules for comparison, but they don't specify any period, and instead they leave that to the tribunal to decide. Now, the reason for reducing the time period from 30 days to 14 days is to prevent cases or prevent delay in cases where the respondent basically has no defense or the issue in dispute turns on some short point of law or fact. Okay, so the whole idea is to have the process speed up, and if necessary for parties to apply for extension of time as the case may be. So in short, the issue for consultation is whether we should keep things as they are, which is to leave it as 30 days, or shorten the time period to from 30 days to 14 days, or even shorten it by some other period if you think 14 days is not the appropriate period. Okay, moving on to the next slide. This concerns Rule 16, 17, and 18. And basically here, the possible amendment is to clarify the challenge procedure as set out in the rules. Now, the current Rule 16 sets out the process where there's a challenge to the arbitrator. Now, Rule 16 has 8 sub-rules dealing with the first 3 rules dealing with the grounds on which an arbitrator may be challenged, reflecting those as set out in Article 12 of the Model Law. Rule 16.4 to 16.6 provides for a notice of challenge to be delivered to the tribunal, and for the time of delivery of the notice of challenge and the requirement for the notice of challenge to contain the reasons. 16.7 currently provides for proceedings to continue during the period of the challenge, and 16.8 currently deals with the situation where the parties agree to the challenge or the arbitrator voluntarily withdraws as a result of the challenge. And if the other parties does not agree to the challenge or there's no voluntary withdrawal, then Rule 17 provides for the chairman of the SCMA to decide on any such challenge, and his decision shall not be subject to any appeal. And currently Rule 18 provides for the removal of the tribunal by the court in certain circumstances similar to those set out in Article 14 of the Model Law. Now, the proposal for consultation here is to recast the current set of rules into 3 separate rules to clearly outline the applicable test, the challenge procedure, and how it is to be determined. Okay, and it is also suggested, okay, as a possible amendment to remove Rule 18 as that deals with basically a challenge that is brought before the courts. I'll expand on that a bit more later on. But let me first deal with Rule 16, okay, the possible amendments to be made here. I think this is in the next slide. Yes, thank you. Now, Rule 16, the possible amendment here is to stipulate the applicable test for a challenge. Okay, the basis for challenge will be expanded slightly. The original ground will still remain, which is the existence of circumstances which give rise to justifiable doubt as the arbitrator's impartiality or independence. Now, an additional ground will be added, namely where the arbitrator does not possess qualification agreed to by the parties. Now, this, if this amendment is made, it will basically put our rules to be consistent with Article 12 of the Model Law, which also allows a challenge if the arbitrator does not possess qualifications agreed to by the parties. Okay, so Rule 16 of the new possible rule will set out the criteria for the challenge. Next, the next possible new rule will be Rule 16A. This is a new rule to be introduced just to set out the challenge procedure. Okay, now by setting out the challenge procedure as a separate rule, hopefully this will make it easier to read this in conjunction with Article 18 of the Model Law, and to understand that this is a procedure agreed by the parties pursuant to Article 13.1 of the Model Law. Now, substantively, the provisions will remain more or less the same. Okay, so basically you still have to deliver your notice of challenge. The notice must contain reasons, so on and so forth. Okay, and then the third possible amendment is in Rule 17. Okay, this will deal with the how the challenge will be determined. And again, substantively, it will not be much different from the current rules. Basically, the chairman will still decide on the challenge, and his decision will not be subject to an appeal within the framework of the rule. But of course, they do exclude the mandatory provisions of Article 13.3 of the model law, which provides for a limited right of intervention by the court. Now, just now I was mentioning Rule 18 to be deleted. Now, in conjunction with the proposed amendments, it's proposed that this, okay, I shouldn't say it's proposed, a possibility is to remove Rule 18, because Rule 18 deals with removal of the arbitrator by a court of competent jurisdiction. Now, this removal of an arbitrator by the court is essentially a separate process from the challenge procedure, and the committee doesn't think that it's appropriate for the rules to purport to confer on the court the right to determine an application to remove an arbitrator, or the grounds on which such an application should be determined, or who has standing to appear before the court. So such matters, we think, are best left to be determined in accordance with Article 14 of the model law, hence the proposal for removal. Okay, so in summary, the issue for consultation is whether you agree to the rules on challenging an arbitrator being recast into separate rules with minor amendments, and also for Rule 18 to be deleted. Moving on now to Rule 22. Okay, Rule 22 is a sensitive one, and it concerns the possibility to move the default seat of arbitration away from Singapore. Now, currently, the rule deals with the juridical seat of arbitration and the physical venue or place of hearing for the arbitration. Now, under the current framework, Rule 22.1 provides for Singapore to be the default seat, and Singapore to be also to be the default venue for holding physical hearings and meetings. Now, the issue for consultation, insofar as the seat of arbitration is concerned, there's an option to agree a different jurisdiction, different seat, okay, exists under the rules as they are, okay. Now, and the concern here is that there's been cases where parties adopt the rules, the SCMA rules, but with a foreign seat. For example, a seat in London. Now, the concern here is that this can cause a tension between the SCMA rules as they presently exist and the arbitration law so chosen. Okay. Now, with respect to the physical venue or place of hearing, Rule 22.3, it bears noting that most arbitral rules do not stipulate the physical venue for the arbitration. Now, an express provision can, however, be helpful. It promotes certainty and avoids the need to consider the venue in each case. And further, the current rule does preserve the party's right to choose a different venue, or for the tribunal to direct a different venue in appropriate circumstances. Now, if you look at the consultation documents, actually there's you don't see any changes here, okay, to this rule. So nothing, no possible changes is being proposed here, okay. But instead, we are seeking your feedback and comments on whether or not there should be any change. In particular, whether the SCMA should move away from having Singapore as the default seat, and if so, why? And those of you familiar with SIAC arbitration, for example, would know that SIAC now no longer has Singapore as the default seat. And the second question is, of course, whether it's desirable to retain the current Rule 22.3, which provides for Singapore to be the default venue for physical hearings. Okay, so have a think about this rather sensitive issue, and please give us your feedback. Moving on now to the next slide, Rule 25. Thank you. This is on the issue of conferring the tribunal with overriding discretion over the conduct of the proceedings. Under the current framework, Rule 25 confers a wide discretion upon the tribunal to ensure the just, expeditious, economical, and final determination of the dispute. However, the discretion of the tribunal to decide on procedure and evidential matters is still subject to the parties' agreement. In other words, party autonomy prevails. Now, in order to promote efficiency and to ensure that maritime arbitration remains economical for the parties, a balance needs to be struck between party autonomy and control of the proceedings by the tribunal. Now, the possible amendment here is intended to address the concern of parties who fund dispute resolution and who have commented on unnecessary delay and cost in maritime arbitration, which could have been avoided if the tribunal had given more robust directions. Okay, so the possible amendment that's been considered here, well, first of all, it should not be misconstrued as an attempt to facilitate or promote institutional-like control over the process, or to fundamentally change the practice or approach of maritime arbitrators. Instead, we are hoping that this amendment will encourage tribunals to make directions that would minimize delay and cost, but at the same time, always mindful of any agreements which have been made between the parties. So the proposal for consultation is, in short, 3 issues. First, do you agree that we should impose an express duty on the tribunal to ensure the just, expeditious, and economical disposal of the dispute, or merely empowering the tribunal with a discretion to achieve these objects? So at the moment, it's still a discretion. So the possible amendment here is to change this discretion into an express duty to be imposed on the tribunal to ensure the just, expeditious, economical disposal of the dispute. Now, the second issue is, do you agree that the tribunal should be empowered with the widest discretion, such that while the tribunal is to have regard to the parties' agreement, the tribunal will not be bound by it? Okay, the idea here is to enable the tribunal to ultimately decide what procedure to adopt in discharging its duty as set out in Rule 25.1. Now, the final and third issue here is whether you agree to the amendments to the questionnaire at Schedule A. Now, in order to enable the tribunal to discharge its duties under Rule 25.1, a more comprehensive questionnaire has been proposed. Okay, so I won't go through the questionnaire on what the possible changes to the questionnaire should be, but please take a look at the questionnaire and give us your feedbacks and comments on whether changes should be made to this questionnaire. Okay, moving on now to Rule 27. Thank you. Now, Rule 27 concerns change in the parties' representatives. Okay, and the issue here is whether we should make it subject to the approval of the tribunal. Okay, currently, Rule 27 provides that any parties may be represented by persons of their choice, subject to proof of authority as the tribunal may require. Now, the rule is, however, silent on procedural requirements for any subsequent changes to a party's authorized representatives. In particular, late changes which may potentially impede or prejudice the arbitral process or embarrass the tribunal in its constitution. Now, the proposal for consultation here is whether Rule 27.3 needs to be amended to provide for any change in party representatives to be subject to the tribunal's approval and to confer upon the tribunal the power to withhold any such change where it is satisfied that such change might prejudice the conduct of the proceedings or the enforceability of any award. Okay, so please have a think about whether we should do this change, and let us have your feedback. I now hand over to Sapna to continue with the rest of the slides. Thank you.
Thank you, Kenny. Sapna, you can take over now.
Thank you so much, Puneet. Thank you. So I shall now deal with the last tranche of specific possible amendments that we are looking at, and they really fall into three areas. The first is the circumstances under which oral hearings must be held. The second is the small claims procedure, and in particular, the threshold for the small claims procedure. And the third relates to the decision-making by the tribunal, and specifically how many members of the tribunal are required for a decision to be binding. So the first I shall look at is Rule 28, which relates to the possible removal of what we currently have in the rules, which is the mandatory obligation to hold hearings unless the parties have agreed to proceed on a documents-only basis. Now, there are two possible approaches which consultees are being asked to give their views on. The first will be that where the parties agree on adopting the rules, the tribunal shall decide without any necessity for the parties to agree, and even if one of the parties requests an oral hearing, it's the tribunal that shall have the entire discretion to decide whether or not a hearing should be held. The other approach is that if the parties agree, or if any one party requests that a hearing should take place, then a hearing will be required. So ultimately, what consultees are being asked to decide and give their input on is what level of discretion they would like the tribunal to have in relation to whether or not a hearing should be held. And I think the key issue underlying the possible approaches that may be taken is that the hearing tends to be where most costs are expended in any arbitration. So if a tribunal has more discretion to decide whether or not to hold a hearing, considerable time and costs could be saved. Whereas what we have now is that in many cases, a respondent can drag out proceedings and put a claim into the expense, the considerable expense of a hearing. And if we hand more discretion to the tribunal, there may be the possibility of an arbitration proceeding more efficiently and more cost effectively. So moving on to the next area of possible amendment, and that is Rule 34, decision-making by the tribunal. The current framework provides that any direction, order, decision, or award of the tribunal shall be made by a majority. And there are essentially three possible amendments which are being considered here. The first is a possible amendment providing that the decision of the presiding arbitrator shall prevail where there is neither unanimity nor a majority amongst the tribunal in terms of the decision to be made. The second possible amendment, which is currently being considered in Rule 34, is to empower two arbitrators who are already appointed to make decisions, orders, or an award, and to proceed with the reference until they cannot agree on a matter. Now, there are advantages and disadvantages of this approach. A disadvantage, of course, is that in the circumstance that parties have agreed to arbitration by a three-arbitrator tribunal, this rule will essentially deviate from what they have agreed. Secondly, one advantage is that a decision on obvious matters does not require a third arbitrator and obviously will avoid the additional costs that would be expended where the input of a third arbitrator would be required. So consultees are invited to give their views on both these possible approaches, and there is a last amendment that is possible to Rule 34, which I shall move on to. And that is a possible amendment that a decision on procedural matters may be made by the presiding arbitrator alone. Now, of course, the disadvantage to this will be that there is, of course, a risk of a presiding arbitrator making an error. An advantage is, again, there will be cost savings, often for each procedural matter, if there requires to be a decision with input from all three members of the tribunal. There can be considerable emails, calls and discussions between the tribunal members, which will add to the cost of the reference. And most of the time, that level of consultation is not necessary for procedural rulings. So consultees are asked to consider this particular option as well when looking at the possible changes that there may be to Rule 34. So moving on to the small claims procedure. Now, the current limit for small claims under Rule 46 is $150,000 US. And the current position is that the small claims procedure is mandatory for cases below that value threshold, but can be applied for cases above that threshold by agreement of the parties. A possible amendment which has been put forward is to increase the current limit from $150,000 US to $400,000 US, really trying to create a more attractive and user-friendly small claims procedure that really could become a hallmark of SCMA arbitration. Another approach that is being considered, on which we invite feedback from consultees, is that the chairman of the SCMA shall decide whether or not the SCMA small claims procedure should apply upon the application of any party, and will consider issues such as the value of the claim, so whether or not it is below $400,000. Secondly, whether the parties have agreed. And thirdly, a number of other factors, including the nature of the dispute and the complexity of the dispute. Many other small claim procedures of other institutions proceed in a similar way, where there is an application made by a party for the small claims procedure, and the chairman or decision maker at the institution will decide whether or not the small claims procedure should apply. So it gives more options for the small claims procedure than what we currently have, which is either it's mandatory because of the value of the claim, or it's by the agreement of the parties. This could certainly widen the category of cases in which the small claims procedure may be applied. So moving on, there are other consequences of potentially increasing the limit of the small claims procedure, and I'll just mention a couple of them. One is that instead of the current provision that there should be no reasons, it's proposed, or at least a possible consequence of increasing the threshold of the small claims procedure, is that brief reasons would be given. And this really would reflect the fact that this would now be a more substantial claim in dispute. Another possible increase would be in the level of legal costs that may be recoverable, and that's referred to on this slide. I think that's it for small claims. If we move on, there are similar changes being considered relating to the use of the Singapore bunker claims procedure for disputes of sums not exceeding $100,000. Currently, the SBC Terms, which is the shorthand for the Singapore Bunker Claims Procedure, will apply where the parties agree, but a possible amendment would be to empower the registrar, upon the application of a party, or if the parties agree, to direct a dispute where the value of the claim and counterclaim is below $100,000 for it to be resolved under the SBC Terms. So again, there would be a possible expansion of the scope of cases in which the SBC Terms may be applied. So that's it for the specific possible amendments that have been set forth in the report. And I will now hand back to Andrew, who will talk about what we've termed possible structural amendments. Thank you.
Thank you, Sapna. Thanks, Andrew.
Thank you very much. So very briefly, everybody, you'll see here a list of some new and some old chestnuts in international arbitration that we have included for completeness in this third section of the consultation. It's really a matter for you as consultees whether you are gripped by any of these particular ideas that have currency in other fields of arbitration, and whether there is any benefit in the importation of any of them into maritime arbitration. You'll note that I'm not completely enthused with all of this. It's obvious. I'm sorry, I can't hide it. We are dealing with maritime arbitration. I began by talking about a tried and trusted method. And if we adopt these sorts of ideas, then we're going to have a very different beast to that which we have all been riding for, in my case, certainly many years. So you see them here. If you are exercised by any of these things and think that they have a place in maritime arbitration, please do let us know. Don't let my evident lack of enthusiasm for most of them in maritime arbitration. I have enthusiasm for many of them in other fields of arbitration. So you feel free to let us know your thoughts on all of these things. I would just draw attention to the last part of the slide, views sought, and the point that's made there, that if there was a strong wish amongst consultees for some of these features to be brought in, and we've identified them there, perhaps inappropriately, we've used bullet points and letters in the note at the end, but you'll get the drift. We are going to have some pretty radical structural and funding changes to make some of these things work in maritime arbitration, with obviously consequential costs, effects for parties taking up SCMA arbitration. I won't say any more about that. I'm going to hand back to Punit now, who is going to tell you how to participate in this consultation process. Thank you, everybody, for listening to us. Very much appreciated that so many people have joined.
Thank you very much. Thanks, Andrew. Thanks, Sapna and Kenny as well for their contributions. Now I can try and go to the last slide, which is basically how to participate effectively in this consultation process. I think we need to see as broad a participation as we can, because we really believe that we need to see as many views. Andrew and the other panelists have already mentioned that these are possible rule changes. They are not something that are done, given. We are needing to see a lot of different viewpoints to come in. So moving with times, all the responses to the public consultation will only be in electronic form. So people sending in mails and letters, sorry, but that's not happening this time. It's going to be only electronic form. The three documents that you will need to respond effectively are, first and foremost, the public consultation documents. These slides that have been created in this presentation are basically from that very document. And that document is available in two places, and obviously can be accessed in three ways. First is you can actually access it on the SCMA website itself. So if you actually, and I can click on this to share the screen with you as to what will happen. If you actually see this particular place, I'm not sure whether you're able to see my screen. Let me see if I can reshare my screen now with the actual, yeah, there you go. Sorry. Yeah. So this will take you to this particular page in the SCMA website, which actually has the public consultation document. And if you click on that, you will actually be able to see this entire document, which is essentially summarized in this PowerPoint presentation. By the way, we are also live streaming this very webinar on our YouTube channel, the SCMA YouTube channel, a recording of which will be made available to all the members and all the participants. So hopefully you can get a background on this exact webinar discussion as you go along with it. Again, you will actually see that this is having all the information on the various rules, the changes, the views sought, the proposal for consultation is all highlighted. So you have all this very information. There is at the end of this document also a detail of where the consultation feedback can be sent. Sorry, I just need to go down to the last page. Yes, and that's the feedback. It can come straight to my email. And the period is, as I said, 16th June to 31st of August. There is also a link to the procedure committee report, which is in full. And I'll talk a little bit about that as well. And of course, that is one part of it. The other part, which I will come to, the second document is this particular document, the Microsoft form. You do find that this very consultation exercise can also be done electronically using a Microsoft form. And a link will be sent by email to all the participants across the industries. And we will actually look forward to have electronic responses if we can. Now, if I click on this, it will actually bring you to something, and I've just created, I'll just show you what it look like. Yeah, it will actually create something like this. I hope you're able to see the screen with the form in front. Andrew, you're able to see it, right?
Yes, I can see it.
Okay, so this will bring you to this page. On your computer, on your desktop, if you click that link, it will actually open up with this very, and you can see all these questions are mentioned, views sought, and you can enter your answers. There's a limit of 4,000 characters for each of the answers, so there should not be a problem. And you simply have to answer these questions and click submit at the end of the day. There is some rating reviews at the end as well that you can try and fill up, please. If you're doing it on your mobile, you will see it like this. You will actually see all this information on your mobile. It will give you all the answers in a very systematic form so that you can actually look through it and fill in the questions. If you do decide to fill it electronically, we would advise actually desktop to be a better option. And as you can see, if you do have the option or the access to the other two documents, which are the procedure committee report as well as the current SCMA rules. If we click on these, this will actually take you to the website, again, of SCMA, where the procedure committee report is actually stored. It's publicly available. And if you click on that, you will actually see the entire procedure committee report with their commentary in detail on each of these rule changes. This is effectively a mock-up of the possible new rules. So for example, if you remember Andrew talking about rule 4.3, which is a new rule, and that's already here. So this is how it will look, and this is how it will actually possibly look. So it's very interesting that you actually get access to this. You will have to, of course, refer it to this particular document as you go along all the time. And finally, there is also the access to the current rules, which is also on the SCMA website. Obviously, if you are on your mobile and you need to access the form, you can also scan this QR code, which is also going to be sent out to the participants. So you have the easiest possible way of accessing this public consultation. And along with all the other supporting documents, we hope that you can get a good overall picture and give us a very, very positive and constructive consultative exercise going forward, which we really look forward to. That's all from my side. And as I said, we will be sending out emails to all the participants across the various industries, various parts of the globe. And hopefully we'll have a good participation going forward. At the same time, as I said, the YouTube video will be made accessible as well. If anybody has any specific questions or answers, please feel free to come back. Right, so I think there have been some comments. Thanks, Waipong, on the comments. Are there any other specific questions that we can answer for the participants currently? I'll stop sharing the screen now, because obviously that's the end of the presentation. We are, of course, as I said, still streaming on the YouTube on our SCMA channel. Please do follow us also on our LinkedIn and other social media channels so that you can keep yourself updated with the latest updates from SCMA. We are trying to make that a lot more robust and aggressive going forward. And this consultation exercise will also hopefully give us a flavor of the fact that we want to get more techno-savvy going forward with all our activities. So hopefully we will see that going forward. I still don't see any, I see a few comments, mostly from Waipong and others, basically on the YouTube streaming, which Vinny has replied. I don't see any other Q&A. So obviously, looks like Sapna, Kenny, and Andrew, your presentation was so clear that everybody's understood exactly what it's all about. So there's no further questions. Then I would just like to call this to an end and just basically thank all the panelists and all the procedure committee members and Corina and John for their work going forward. I look forward to the consultation exercise going forward. And with the analysis, hopefully we have much more robust and dynamic and up-to-date rules going forward. So thank you very much for all the participants and all the attendees as well. Thank you.
Thank you, everybody.
Thanks a lot. Thank you.